Now, my heading continues with the rule of law. And this address seeks to deal with the overall macro developments in the building or the beginnings of the colonies, coming together of the Federation of States, of intended rule of law at that time, of improper court determinations since, of referendums and sovereignty issues, and finishing with where these various particulars might lead us as we consider the future in or for Australia. We should spend a moment in retrospect, for at two previous public education meetings we looked at a couple of angles to the rule of law for governance in this country. On March the 8th, 2011, I addressed the way the rule of law in governance is supposed to be practiced in Australia with the constitutions at both state and Commonwealth level as originally set up by the British. I had a little diagram. You see my diagram up on the board there, and it identifies the authority from the battery end of the car powering through to the lights at the end, and if everything's right in between, we had proper law. I reflect on the authority of the Imperial Parliament and the Crown of the United Kingdom of Great Britain as the primary authority in that context under which all law operated, and the Governor-General and the state governors being part of that setting. On March 19th last year, I explained how the rule of law is fractured in quite a number of ways. That typifies what's happening.
You have to get a roadworthy paper.
You should take it off there.
Hardly roadworthy. And I showed there are many infractions to the Constitution and the way the rule of law is being managed in this country today. It was established with the original system, that the original system is not operating, and that since 1973, no statutes from respective parliaments at either federal or state levels were lawful. There is in place in Australia an Australian system of government which is there without referendum approval of the people and the nation. The past 3 years have been a continuing journey of learning for me. I wonder how you are going with your journey, your discovery in these matters of constitution and of the rule of law. Meantime, you are permitted to ask, where do I stand today? And my thoughts are placed before you in the context that we are told by the governments we are acting according to the rule of law. So the issue is, do they? Do we? Let us move forward. In the original macro settings, in the early 19th century, Australian law was set up as British law within several colonies. The rule of law for governance was based on natural and common law and with the sovereign authority of the conquering elite. Wikipedia tells us that natural law, or the law of nature, has certain aspects to it, and I'm not going to go through all those details. But the fascinating thing is that the United Kingdom established a law set up in Australia despite international law at the time. I say that again, despite international law at the time. In point of fact, no sovereign right could be said to exist as established by Britain unless one of three things was in play. For to hold sovereignty at the end of the 18th century, international law required three things. One is that you conquer the people and take the landmass, and the UK didn't do that. Two is that you treaty with the inhabitants, as New Zealand did in the Waitangi Treaty of 1840. Or three is you occupy an uninhabited place. But Australia was inhabited. So none of these were so. And terra nullius could not apply. It was in fact a lie held over many years by a sovereign elite as a convenience for the Crown. Questions therefore hold as follows. A. What standing did the UK have to impose its laws in 1788? Very interesting question. B, how could it claim sovereignty when it could not uphold the claim to sovereignty pursuant to international law at the time? C, can it properly be held that the UK did obtain sovereignty in or over Australia in the meantime? And when might that have been? So we're just looking at what our history might be and how things might be said in that context. And then, can we say Australia has become a nation in its own right under the law of the United Kingdom, with the Crown of the United Kingdom still in the constitutional setup, since no referendum has yet removed it? If so, and we've gone to a Queen of Australia, how did this happen constitutionally? These questions can be juxtaposed against those who were here and what law did exist in Australia with the then sovereign native peoples and what standing British law might have in the middle. So you're looking at existing population with their sovereign right to the country, to the land. It's their country. They call it country. And the bottom line there is, how did Britain become involved, and what might the sovereignty of us, as we look at ourselves together as a collective people in the country today? I'm trying to give you the macro picture here. You question your way through it. Interestingly, in 1992, the Mabo determination began to open up the matter as to what sovereign Aboriginal common law could be respected. Interesting question there. It opened a window in white man's law to a future for Aboriginal rights, in inverted commas, of sorts. It certainly brought the issue of common law rights, tradition and culture for Indigenous people to the forefront. But did it do justice for the First Nation people in the setting, and what then came to be sidestepped by the Native Title Act 1993, Commonwealth law? Whilst it is probably fair to argue that there are many good parts of the law brought to Australia, there are unresolved matters including the sovereignty of Aboriginals, the status of the rule of law for governance in a country not conquered, standing of the Australian Constitution 1900, its development, its progress without referenda or otherwise to make appropriate changes. And what can be said about the present place of a constitution? Sovereignty of all living people born here, including the Indigenous, a sense of everybody being born is Indigenous, truly. And therefore we must move to consider the way the Federation of States came to be as we look at it and to develop our journey forward from there. So the Convention debates of the 1890s were the basis for a draft bill approved by the colonial governments. The draft bill was the subject of a referendum held in the colonies across Australia and approved by them. But Western Australia held out right to the end. Now, Wikipedia records that in 1899 several years of lobbying had been going on, and the Eastern Goldfields Reform League had compiled a petition to Her Majesty relating to the cessation of the eastern half of Western Australia. And that was in the pipeline in 1899. The then Western Australian government busied themselves to petition, I'll back up. In early 1900, Walter Griffiths travelled to London on behalf of the Goldfields Reform League to present the petition to the British government and lobby the Colonial Office to either approve Auralia, which is the name they gave to this Eastern Secession section, or force the Western Australian government to accept federation. So that was the question at the time. Nevertheless, the petition put pressure on the Western Australian government to join the Federation of States. And Forrest led a push to include recent immigrants from the East, so that bolstered his numbers. And also as well, they granted voting rights to women in 1899. So the political play at the time was to get their numbers so that they wouldn't have a separate half of Western Australia in the goldfields, and all of it would retain its, if you like, colonial integrity. You guessed the outcome. there were enough women brought in to add to the vote to get the western half of Western Australia with enough numbers compared to the eastern half with the Goldfields men to actually get an outcome that said, well, we'll be a colonial group that joins the Federation of States. But that was set up then as one colony. So the various colonies lost their identity, they become states, but that was set up under Clause 8 in the Constitution Act as one colony. So we notice over the past 100 years there have been referendum at state and national levels in order to provide direction to the future, a dictate of standing from we the people to provide the highest law of the day in the country with the final overriding approval of the Imperial Parliament since Australia was still a colony right through. In 1999 we stuck with a constitutional monarchy at referendum. You remember that? Some of you do. But back in 1899, notice that whilst there were men and women voting, and mainly only men in the national one, we also noticed that the people voting were mainly landholders. Nonetheless, at that time, this voice of the people was respected in law. That's the bottom line that I'm wanting to impress upon you, that in law, referendums have a big place. And the question of a constitution, which is approved by referendum appropriately, is a part of where I'm really honing in on tonight. The Australian Constitution 1900 enshrined referenda in section 128. It holds that we the people have sovereign standing over any or all of the parliaments in the country. That's our place, that's our position. And the parliaments are supposed to serve the people for good order and good government. And the question is, do parliaments do that? The question is, do the courts of the land uphold that constitutional setting? So there was a constitutional intention from the framers in the 1890s that parliaments, both federal and state, would be beneath the people. States were not to continue as sovereign parliaments, as clearly declared in those debates. This statement is possible because the state constitutions became subject to the Commonwealth Constitution at section 106. This is all consistent with the notion that the Federation of States became one self-governing colony, and at that time the colonial constitutions should have then been immediately amended to reflect the new standing of the colonies, now states, under we the people. So I'm saying clearly the courts have wrongly interpreted that state constitutions hold a sovereign place, permitting the state to make whatever statute it wants. However, I cannot more strongly say this is not the way the framers of the Constitution intended and required matters. The High Court, though, in the Cable and Forge cases, has held that there is a constitutional limit as to the extent that states can make statute laws. The other aspect of referendum is that it calls for a lively interest in the affairs of the state. If the people haven't got the interest in the affairs of the state, you haven't got proper outcomes because people are voting unintelligently. Experience shows us that the Parliament is not suitable for development of referenda questions. That construction is elitist and it appears to only serve the interests of Parliament and I believe not the people. There has been no room for citizens-initiated referenda to occur, thereby detracting from some of the real issues that are national issues we're all involved in over time. Presently, any parliament can effectively refuse to explore some of the real issues that should be settled through referenda. Now, all men and women have capacity, or with capacity, should be permitted to vote. I have noted that in the early 20th century it was legislated that more of we the people had a voice. Up until 1967 there was no general vote for the Aboriginal people in referenda issue or in other matters, but that developed up through to 1967. And in the Victorian Constitution Act at section 1A, tacit recognition of the Aboriginal people exists, but that is as far as legislation went. To give Aboriginal common law a greater part to play in the state was too much of a move for the total control by the Crown. We have travelled a distance to see people born in Australia able to vote, together with others who have become citizens. Have we travelled the necessary distance to see the possibility that all people can be educated well enough with sufficient interest to properly use their vote? You really hear my heart there. We've got to be working more. So educational institutions must be adequately teaching all in the nation about constitutional law and right. If not, the point is, why don't they do it properly? Looking at the Australian referendum record for more than 100 years, we see over a dozen important state and territory referenda, ranging from, in example, 1933, the WA state was considering leaving the Federation of States. We've got self-government issues, daylight saving issues, fixed terms for state parliament issues, and for national referenda we see there to be 44, with 8 providing a yes vote. Topics ranging from industrial to legislative powers to constitution and election issues to having Aboriginal people involved in national affairs. So mention was made of the lack of attention to amend all of the state constitutions to conform with the Commonwealth Constitution with referenda as part of the setting in each state in order to become truly subject to the Commonwealth Constitution. So that's another problem that hasn't been teased out properly, that people haven't had a chance to work that through. Mention was also made of an attempt in Victoria to establish referenda with the inclusion of the requirement for a referendum to change parts of the Constitution Act at section 18(1)(b). But that is a limited version of what the state should respect, with the state constitution being subject to the Commonwealth Constitution. In order that you may appreciate some improper settings prevailing at this very moment, I quote current detail from the South Australian Government website. The Parliament of South Australia, it says, is entitled to legislate on any matter. There is no principle of separation of powers in the state constitution. You're listening. This is what it says there. Nor is the state's legislative power subject to a requirement to preserve fundamental human rights. That's in the state of South Australia. In Victoria, we've moved a little further forward with the Charter of Human Rights and Responsibilities Act, 2006. It goes on to say, however, there are certain limitations on the state's legislative power, and it then details a number of points. So I'm trying to cut my time down here and say, then what is wrong with government presentation? Maybe who has sought to try and fix it, and how was that fix done? Consider with me that because the state constitution is subject to the Constitution of the Commonwealth, then there is no possible way separation of powers can be managed as the state wishes. The Commonwealth Constitution has separation of powers. The state can't just blithely override that because it's subject to or sits under the Commonwealth Constitution. So we have pressure points to have to push here to be able to get a more effective outcome for people power. In the High Court of Australia, I've mentioned the cable cases. It established that state laws have limitations. So at least the High Court was honest enough there. In the Forge case in 2006, it established the New South Wales Supreme Court was in trouble with too many part-time justices. This being established through the notion that constitutional conventions also impose upon the state. So what I'm saying here is that not only the written constitution, not only the framers of the constitution details in the debates in the 1890s, but that High Courts bringing constitutional conventions into play to be able to hold a point and tell the state to smarten up. The High Court held that to do otherwise was unlawful. Sorry, there is a limit to state legislation from a constitutional viewpoint, and legislative standards of a constitutional nature must be upheld by the state, is what the High Court is saying. It is totally improper, however, for the High Court to hold that the Parliaments are sovereign now, and that they are therefore able to pass whatever state laws they want, statute law they want. So there's a whole mix that's muddied and I'm not happy with. I'm not going to go through those other points, but the point I'm coming to now is that clearly there is no three tiers of government. The federal and state levels are constitutionally established, and the language government at the third level, so-called, should be, we speak municipal councils. We do not speak local government. They are municipal councils, elected representatives to represent at the local level. The question for all states and the Commonwealth is what have they morphed themselves into, and how does that fit the law of the land? So what place does COAG have in the scheme of things? All of these questions are out there. What has to be done to bring macro correction, which is what I'm dealing with tonight, to our status as a new nation and to our standing in relation to proper operation of a proper constitution. So, presently the federal parliament and federal courts use constitutions when it suits them. That's the conclusion I've come to.
It's an illusion.
The same notion can be stated in relation to state parliament and state courts. The highest law of the land has little standing in many avenues of power due to various and serious hiatus in the document. And I've dealt with the hiatus of the rule of law in my last lecture a year ago. The idea of a current constitution is difficult to project since there are many major infractions to the constitution as things stand. I say that because there are now corporations operating at state and federal level without lawful and constitutionally correct standing, we have real problems. And some say that there is a Queen of Australia, all done without any approval at the referendum, at a referendum to provide for alternative constitution crown to that of the United Kingdom of Great Britain. All of that just adds to the problems. Now, an attempt was made in 1973 to change things, albeit change the unlawful things. And the Royal Styles and Titles Act was supposedly passed by federal parliament, but that's never been given approval at the UK end. We've got documents proving that. With the Governor-General acting as a representative of the UK monarch, without the Governor-General acting as a representative of the UK monarch, there is no constitutional power to approve anything. The Queen of Australia is really out of the picture. Now, the Royal Styles and Titles Act actually has a detail in it that requires the signification of the monarch. And that can imply that the Parliament of England actually signs it out on behalf of the Crown because the Crown's part of the Parliament. The bottom line is that we have documentation identifying from Windsor Castle at the palace that Her Majesty has not actually signed that document out. The Parliament has not signed that document out. So I'm just reinforcing to you that the Royal Styles and Titles Act bringing in the Queen of Australia has no legal standing from the point of view of the rule of law for governance processes. So notice other documents have been signed by Whitlam as the Prime Minister, as if Her Majesty, as the constitutional crown of the UK, had authorised him with new commands. Not so. Finally, the so-called Great Seal of Australia is not the constitutional seal, since no referendum has given approval on these constitutional matters to change the seal, the constitutional seal of Australia. So Australia's been sold a pup.
It's been sold full stop.
Since 1973, there's not been constitutional rule of law for governance in this country. It is reported an attempt has been made to fix something of the problem. An Australian lawyer by the name of Fitzgibbon attempted to do that in 2005. The problem was he argued before the High Court in London, and he was holding that the last 4 Governor-Generals had been incorrectly appointed. And a chappie by the name of Justice Gavin Lightman in the High Court in England noted that not only did he have no say over the case, very interesting, he dismissed the case. But even if he did rule in favour of Mr Fitzgibbons, the Australian government, watch, independent since 1901, could ignore him completely. Totally wrong. Totally wrong. It seems the good judge had no appreciation of the imperial law that provided for the governments of the country through the Constitution of the Commonwealth, with the rule of law details for governments of the country under the UK Crown. He was misguided. At no time has there been a referendum to alter the constitutional crown, and at no time has the Commonwealth of Australia had capacity to alter imperial law. So there's a conundrum. This decision was in fact what I call a convenience, and it was or is an unacceptable piece of legal or court malpractice. I reflect now that in Ireland they had a constitution which developed mainly by the UK in 1922, when the UK stood aside from most of Ireland. So you were left with that northern bit of Ireland under UK control. There was a constitutional referendum of the Irish people in 1937, amending the 1922 model. And in a later document, the Supreme Court of Ireland respected the argument placed before it that the 1937 Constitution should be respected, and the High Court accepted that. So the movement into a new place is through referendum. It is through the placement of a proper constitution the people want and approve.
When we had the last referendum...
Can I handle questions at the end? So at this point I want to highlight that when the people speak through referendum, the courts in the land have a responsibility to uphold the detail. In Australia there is difficulty to obtain justice in accord with the Commonwealth Constitution because the courts of the state will readily accept the so-called state standards required of them, and they're being dictated to by the state government, in my view. But to get to the High Court and hopefully get a proper outcome is a very expensive exercise. And I've come to the conclusions, I've looked at these matters over 3 years working with Ratepayers Victoria, that the interest in the people is not enough to actually get it there with sufficient oomph, and the money supply to get it there isn't there, so you can't do it. So that's where I'm at. There are some other aspects which Dick Yardley and Larry Hannigan have been working on, which I won't necessarily go into. But we do need referendum to tidy up constitutional arrangements. And I was speaking just earlier this afternoon with Charles Mollison, who's a retired Army high-ranking officer, who would know Peter Cosgrove and a couple of others that I'm also familiar with. And Restore Australia is a group been working for the last 15 years with the idea of developing enough public interest in the question of enlivening the need for a new referendum, a new constitution. So we need to be working together across Australia to pull something like that together now. Now in the past High Court Justice, Michael Kirby, suggests we need 6 people at the Governor-General level. Not just a Governor-General, but an oversight to the Parliament with 6 people, and I suggest 1 from each state and or territory if you like, 7. But the idea then, if they take office for 6 years, 1 could take it in turns year about to be the head of state if you wish to develop it that way. But that's only one part of the problem. So I suggest the relationship between federal and states parliaments be such that duplication of services be removed, so we become more efficient in how we operate in the totality as a nation. And the other side of it is to actually work out how better to get the efficiency of taxing levels examined. And so you're looking at where does local councils, as municipal councils, fit in the taxing regime. Example here is that $1 of every 10 is spent out into the community properly by councils, compared with the other way around, where apparently $9 of every tax collected is spent back out into the community by the federal and state governments. So councils are hugely inefficient in handling matters of tax and spending
Everything.
back into the community. So what powers are proper to place in the hands of the federal parliament in the 21st century? What to do with the operation of the states as they exist? How do you juxtapose the current COAG arrangements and the present GST payments collected by the federal government and placing money back in the hands of the state? What to do with the very inefficient taxing systems I've mentioned? What to do with church and state? What to do about UN Agenda 21 and with UN treaties overall? What to do about ancient entrenched law of the land, Magna Carta, 1215 and so on. So there's a range of things that my mind turns to that we must address within the context of a new constitution. A recent article from The Guardian in the United Kingdom draws our attention to the banking setup there. It aptly identifies that the banking system produces fresh credit into the community. It is not the way the average mum and dad thinks about money put into the bank lent out for business to use. There's a hugely different picture. And the bank's paper, money creation in the modern economy, is a very high-ranking paper produced for people to ponder on. And I can help you look at that if you wish. I'm not going to go into the details, but sufficient to say tonight that when banks make loans, they create money. And so the whole question of bank lending creates deposits. So freshly created money into the hands of businesses, mortgage holders and so on, causes money to be circulated, which comes back as deposits, and it causes the government to have a taxable area to work on from private incomes and from business profits. So the government's really happy in this sense, but there's more to be done with the whole question of banking. Why do these issues become so important in the macro rule of law? In a few words, it is because it governs how we view money. It governs what can be done. It opens the issue as to how power is played and how governments can use money as a fresh issue for the benefit of the people in a big way. If there's a will to do so, that will has to be rediscovered. My federal MP has responded that it's not in the mind of the government to go in the direction of creating a government bank to be able to provide fresh money into the community without cost to the community. So all the government looks at is, can we tax, can we borrow, can we issue bonds? They're the areas that they basically look at. Dealing with sovereignty, Malcolm Fraser says we should be finding ways of asserting Australian sovereignty. Well, what does he mean? In the context of this conversation, he's raising the huge question as to whether Australia can claim to be a sovereign nation. I suggest the issue has a root in that people's sovereignty has to be re-established and the Parliament becomes servant of the people again. These areas are major issues for this country and we need to move to solve them in the immediate future. When democracy is managed by the Swiss, and that is applied here, then we will be able to say our country is democratic. Otherwise it's not. The word democracy is meaning rule by the people. And to be saying your representative government is representing you and doing things for you is not actually you making decisions about certain things. Decisions should be made on at a national level. There are many great points in the present constitutional setting, and we have the notion of our people humbly relying on the blessing of Almighty God. We have the court systems with merit compared to other countries, but they must come away from making determinations in the best interests of the Crown. It's got to come to be the best interests of the people. Decisions must be made in the best public interest, and decisions of juries must stand without a judge getting in the way of any decisions of the people. When people in government have appreciation of the correct facts regarding money, its creation, circulation, supply, and then we will all be better off, and austerity, poverty and hardship can be alleviated. So when you look at the rule of law for governments, you're having to take into account all of these factors, money being a big part of that. I trust that the points offered this evening assist you to appreciate the difficulties we have before us on one hand, but that there is a way to move forward as a nation with proper constitutional conventions and referenda on the other hand, with support from all concerned people. The sad thing is there are many in the legal profession in Australia who are well aware of these matters, but they are very reticent to be involved with willingness to stand in the gap to work to fix it. I invite you to look at the challenges and to rise to the occasion with me and others who have a common care for the rule of law for our governance. Thank you.
Okay, Peter will take a few questions. Okay.
Peter, this is not a question but maybe a fact. We're talking about local government. We, Ratepayers Victoria, by the way, I'm president of Ratepayers Victoria, I wrote to the Monash Council and asked them under what section of the Constitution do they act. I got back an answer. We do not answer such trivial questions.
They always say that.
For the community here, could you also explain where that Mayor's letter has gone?
I've got it. I've got a copy of that
Can you
letter.
publicise it?
We are currently putting together a file to send to the Inspector General.
Thank you. So we're doing some background work that is important to actually push to get
Well,
changed.
under statutory law, under corporations, it's a frivolous question because they're not under common law. They're not talking, sovereignty. They're talking citizenship. So the thing is that they're over there in their little world, and we're trying to get out of that bloody world that they put us in, or tried to put us in with our birth certificates. I say, give them our birth certificates. Anyhow, and we're trying to get out.
I understand.
So how do you get out of it? The only way I can see is have a revolution.
Okay, next question.
I'll join you.
Next question, sir.
Everybody's talking about this, that and the other thing and all the problems. One of the biggest problems is cost shifting. Does everybody know what cost shifting is?
You're talking about council cost shifting and against the
State
state
government
government?
cost shifting, Commonwealth government cost shifting,
Yes,
council's cost shifting.
yes. I understand the comment and
We're talking about accountability, nobody knows what's going on when there's all this cost shifting going on.
Could I say that it's not cost shifting, it's council tax grade.
Yes.
the paper that George released tonight will help you understand the push that's going in to overcome that problem.
Peter, I just wanted to hear what your opinion was and see if maybe, I saw this young lady here tonight and they're working towards these positive things, that's great. But how do we work towards, because I see it like this, they've got a local government faction or whatever you want to call it, department who assess the council's performance and then put out a report about it. Now, I see that as like, that's like going to the police to complain about the police. And how, now this is the thing, they claim we live in a democracy, how do we get them to pay a body of elected citizens to be that body that oversees the council?
Okay. 2 points. One, yes, dealing with what the
Would they
lady
want to
was
be
saying
living in a
tonight.
democracy?
And she's involved in policy around moving forward in what I call scratch me stuff.
She should be here listening to this what we're talking about
Yeah, how
now.
come she's
I
allowed
don't
to
know
leave?
why she left so early.
I've got to be
So in a democracy, if it was a true democracy, isn't that something that the council should be working towards with us?
The second point that you're raising here is, my answer is, recently Ratepayers Victoria wrote to the Minister to invite the Minister to put Ratepayers Victoria on a panel of mayors that is an annual meeting of mayors, where it's just simply the council people are scratching themselves and feeling good.
Yeah.
And we need more independent and more particular people representation So the response has been just the other day that we'll just consider handling it with the mayors for the moment.
Keep it in here.
Okay, next question.
Think they do this with all things. If you look at this evolution that she talked about,
Yeah.
did you get invited? Did I get invited? I've been a thorn in the side of my council for 15 years. But I didn't even know it existed.
We understand.
But by talking with them, you're accepting their authority.
Thank you.
And that's why I don't accept it.
The MC is...
And please speak up.
Yeah, just elaborating with, you know, what we were talking about just now. As far as having elected representatives that oversee what the government are doing, who are overseeing what the council are doing, you know, and then to pay them. I mean, by paying people already, they're corrupted because then they're on the gravy train and it's good for them. They don't want to upset it because then it fits in with their lifestyle and, you know, they've allowed for this because they get paid for that. Secondly,
No, your suggestion.
yeah, secondly, we do already have these paid, elected representatives, supposedly democratically elected representatives, which taxpayers fund, and I don't know why, because these people aren't politicians, they're called councillors, and councillors are the ones who put their hand up at the budget and say, yeah, you can put us in debt all these millions of dollars and build stuff that we don't even want or need, and while people are scraping and saving to pay this ridiculous debt, that you know, councils are looking with MAV to borrow from international markets and using rates as a security, which to me translates as people's land, their titles as security.
A couple of comments to that line of thinking. One is, to what extent should the MAV be acting? Its statute is quite specific. It is there as an insurance group for the councils. For it to be involved in other things is really outside of its proper box. That matter has now been taken up by Whitehorse ratepayers with the Minister. So we're waiting for an answer back on that.
Okay, one more
The new
question.
minister or the old minister?
The new Minister, thank you.
No.
One more question.
Yeah, you took us to a lovely trip from the foundation of this nation. And you pointed out so many laws and mankind who are in charge of somebody or government, and they lead us always to a greedy way which somebody has to pay for it. This lady was talking about the government has created so many millions of dollars. How did they do that one? With the people or without the people?
I think the first slide she had up showed 8-point-something billion.
8.5 billion or something.
Yeah, but the terminology she used was that they generated it. I mean, this was a delusion, that slide. It should have said taxes taken from the people. 8.3 billion.
Generated wasn't generated.
It's just a consideration of their delusion.
Okay, well we're over time. Thank you.
I'd just like to welcome Councillor Bill Bennett, the only councillor who voted against the draft budget.
Oh, thank you, Colin. Good. It's nice
I'd like
to be
to welcome
acknowledged.
Bill.
Yes, thank you.
You still working there?
Do you want me to say?
He's joined us for coffee.
Now, Colin has some other paperwork in his hand. And they're dealing with your opportunity to do something at your council. There are 3 particular documents and they're all similar in structure. They're template letters. The first one is dealing with council law issues. The next one deals with the function of council. And the third one deals with council accounts and money issues. So it is the one on law issues that Jack sent to Monash and got that rather stinking reply. And he's handling that. We do need to be following through on these sorts of things. So if anybody's wishing to follow through, take one or a number of those copies on the table over here on your way out. I can email you if you want to ask me by email for the copies of these in digital form. So you can just change a couple of bits and send it off.
Peter, just an observation in dealing with government, sending emails can easily get lost. Hard copies you want, so if you don't send a letter, send a fax, I'd suggest.
Send both.
I send both. Send both.
Send both.
I can send them out to hundreds.
Yes.
Yeah, but the other end, an email can...
I usually deal with hard copy all the time.
Yeah.
Well, just ask for a
They
confirmation.
make the law of the day.
Most of the time I'll give you a confirmation you've received it.
Can we have one person speak at a time? Mr. Moderator.
Okay, I think at that point we will finish the evening. I thank you very sincerely for coming. You'll be able to go home and find out what the Treasurer has done to you during the evening.
Well, we have a revolution.
Have a revolution.
Can we apply the budget theme, which is smaller government,
Yes.
to local government?
So thank you to Peter. Thank you to Peter.